Hi everyone, I'm Tim Baldwin. I'm an attorney and I'm founder of Property Management Law Solutions based out of Pensacola, Florida. We get a lot of issues that arise regarding the security deposit. Florida statute section 83.49 governs how security deposits are to be received, held, and claimed. Any sort of damage that's caused to the property, or even with regard to a tenant who believes the security deposit has been wrongfully claimed or used, each party has an independent and separate legal action they could file against the other. If the landlord makes a claim on the security deposit and there's not enough money in the security deposit to handle all the damages, the landlord does not waive his right to sue the tenant for those excesses. Even if the landlord did not file or did not deliver a claim to the tenant, does not mean that he's waived his right to be able to file a lawsuit for all the damages caused to the property. And the tenant obviously has a right to be able to file a lawsuit against the landlord if they believe that the landlord has made a wrongful claim on the security deposit. Chapter 83.49 says that security deposits are to be used for the faithful performance of the lease agreement. And so that money is there in the event the tenant violates the lease agreement or some statute relative to the tenant's obligations during the tenancy. There are two basic ways for a landlord to be able to make a claim on a deposit. First is that the tenant has damaged the property beyond normal wear and tear. Another sort of action or claim that relates to that is waste. In other words, the tenant has wasted some aspect of the property. The other way is for the tenant to have monies owed under the lease that he has not paid for. Those fees could be anything from failure to pay a late fee, or failure to pay a notice delivery fee, or perhaps failure to leave utilities on and thus the landlord incurs expenses. Those are fees or costs that may be owed under the lease agreement. The landlord has to have proof or evidence in support of either the damages beyond normal wear and tear or some sort of breach of the contract that the tenant is now obligated to pay some fee or cost as it relates to that breach. One thing to keep in mind as it relates to a security deposit is that security deposits are not deemed to be liquidated damage amounts. The lease and any sort of correspondence sent between the landlord and the tenant should avoid any sort of notion that the security deposit is forfeited or serves as liquidated damages if the tenant breaks the lease or breaches the lease in some way. And so that means that the landlord is obligated to follow the procedural aspects of 83.49. There must be a claim made, and the claim must be made for either the damages beyond normal wear and tear or the lease violation. Now, getting to the claiming period, the statute says that the landlord has 15 days to return the deposit to the tenant if the landlord has no intention of making a claim. And the trigger date is the day that the tenant vacates the property from the termination of the lease. Once the 15 days has expired, the landlord is supposed to give that deposit back unless he has the intent to make a claim. If he has the intent to make a claim, then that time period is actually 30 days from the vacate date. So the landlord must deliver that notice to make a claim within 30 days if he has intent to make a claim. The delivery must be made by certified mail to the tenant's last known address. There is an exception to that, however. If the tenant abandons the property or vacates the property before the termination of the lease and doesn't provide an updated address of where this person is going to be, then the landlord actually is relieved from the obligation of sending the certified mail to the tenant's last known address. But as a matter of precaution, I would suggest that the landlord should just go ahead and certify mail the claim to the tenant's last known address. That way you avoid this issue altogether. Now please keep in mind that there are issues that arise about the vacate date. There are times when the tenant leaves without the landlord's knowledge, or there's questions about what day the tenant leaves. There's questions about when the lease actually terminates. All kinds of issues sort of arise around the vacate date. So landlords need to be aware of this particular issue and really take notice of when the tenant vacates, getting proof of that, getting the tenant to respond to when they actually vacated, and to actually have written confirmation that the lease is terminated. Now, the statute says that the claim must be in writing, so there must be a written document that makes the claims. Now, there are some cases that say that the landlord must be specific on what the claims are, so listing them A, B, C, D, go down the list. So it's like an itemization of the claims and the itemization of the claim amounts. The failure to be specific could raise legitimate grounds for objection, so landlords need to be sure that they are being specific enough so that the tenants have knowledge of what to object to. Another thing that landlords will say is that, well, they don't know the specific amount of damages for the particular damage item. There are cases that say that the landlord at least should make good faith estimates of what the damages are. Another question that comes up is, do I need to attach evidence? Well, you don't have to attach evidence to a claim. However, it might be helpful because the tenant can see what evidence you have to support the claim. One of the common ways that professional companies are doing this is to have cloud database ways of storing the evidence. So you can put it in iCloud or Google Drive or something like that, so that you can store the pictures, store the invoices, and be able to make those things available if you need to the tenant upon request. Now, tenants have 15 days from receipt of the claim to object. An issue does arise, however, in regards to this, because sometimes the landlord may not know exactly when the tenant received the claim. There are some cases in Florida that say that the landlord cannot actually disperse or use the money until the tenant has the 15 days to object. The statute says if the tenant has not objected within the 15 days, then the landlord can use the deposit. However, if the tenant does object, then now there's an issue. There's questions as to what to do with it. Interestingly enough, the statute does not mandate how the landlord is to use the security deposit if there is an objection, or what to do with it. There's actually a lot of confusion out there about that. However, the statute does say that the parties should attempt to settle the matter. So the purpose of the statute is to encourage settlement, to encourage the parties to resolve the matter on their own, not to file lawsuits, not to go to court. I don't have a lot of time in this video to explain this, but suffice it to say, if there are objections made by the tenant, then the landlord should get an attorney who's experienced in these matters to try to resolve the matter according to what the facts are and what the law is. Now, with regard to damages beyond normal wear and tear, this is one of those big issues. It's sort of a gray area. It's one of those things not brightly defined in the law. So it's going to be based on a case-by-case basis. However, there is a 3rd District Court of Appeals case in Florida that essentially says the limitation of damages beyond normal wear and tear is basically a limitation on the landlord that they not require the tenant to keep the property in like new condition. However, the court did say that there's nothing to prevent the landlord from making claims on the deposit for things that go beyond that, or for items that are specified in the lease to obligate the tenant to do this or that regarding the maintenance of the property. Tenants will say, well, damage to the blinds, or damage to the carpet, or damage to the tile, or damage to the cabinets, or things that they would say, well, these are normal wear and tear. Well, that's not necessarily true. And again, I would just repeat, these are case-by-case basis. It's going to require analysis by an expert in the subject area to make sure that the landlord is making the right claim for the right amount, and to see whether the tenant's objections are in fact valid. Now, quickly on the burden of proof. The burden of proof to make a claim falls on the landlord first. If the landlord can show that there was damage to the property and that was the claim made, then the landlord met his burden of proof. The burden then shifts to the tenant to say that that damage was actually within normal wear and tear. The landlord is going to be able to point to damage because most of the time landlords aren't just going to make a claim for no reason at all. So when that happens, then it becomes the tenant's obligation to show that the damage was within normal wear and tear. As it relates to the lease obligations and the tenant's obligation to pay for fees and monies owed, such as cost or for services that the landlord had to render due to some breach by the tenant, those things should be fairly clear. If the lease says that the tenant owes the amount, then the tenant is going to owe the amount. In Florida, courts do uphold the right to contract as long as those terms are not unconscionable. If they're conscionable, meaning they're within reason, then the courts are going to uphold those provisions, and obviously the tenants are going to be held responsible for those. Now, keep in mind, with underlying all this is the requirement that the parties act in good faith. Don't be arbitrary. Don't act without supportive evidence. If you do, you may find that there's a good faith or there's a bad faith claim that can be made by either side. The courts want to see that you're trying to resolve the matter in good faith. To help the landlords in this regard, it's really good that they come up with a proper procedure from the very beginning of the tenancy to the end, and really before the tenancy, documenting the condition of the property before the tenant moves in. If there's a previous tenant, documenting what the damage may have been after they left, and if there's repairs done, documenting the repairs. Take thorough pictures from top to bottom. Store those photos, store the videos, store the receipts, the invoices. You want them all ready in case there is an objection. And that way you can compare, contrast the objection to the claim you made and the evidence that you have of before move-in and then after move-out. I hope this video helps you with regard to your security deposit claims and your issues that arise. If you do have an objection by a tenant, contact Property Management Law Solutions. We should be able to help you. If you're a property management company, please know that Property Management Law Solutions provides a variety of legal plans for you, of which is included security deposit dispute issues and resolutions. I'm Tim Baldwin. Thanks for listening.